Hero. You can see the dogs in the back seat. But anyway, so that was basically it. I think, the few other things I think I bring up, if you look through all the writing, is I do a lot of comparative analysis type stuff, which I think is important. Looking at January 6th, I talk about the Travis Scott concert. I talk about comparing Oath Keepers and their membership to like church-based groups, to the Muslim faith, how there's a small extremist faction that do things that doesn't implicate everyone is doing something wrong or everyone agreeing with them. Also like the CrossFit organization, Black Lives Matter, how Black Lives Matter pushes for autonomous zones, which is basically overthrowing the government. And then I question, where is going to be the consistency with any sort of a ruling specific to Oath Keepers and Mr. Eastman in this case, and where did the plaintiff do his homework for other organizations or other candidates? I mentioned Anchorage candidate for legislative office in this election, Forrest Dunbar, who is an assembly in Anchorage, and the basic issue, he's got some Black Lives Matter stuff. A lot of people support him, Black Lives Matter in Anchorage, worked on their profiles on social media. He was at some protests, right? Is that going to implicate him? And why would it implicate Mr. Eastman but not him? Because they're basically in the same capacity. Is individual, if they didn't do anything violent or unlawful, they're just there at a march or a protest, showing support, solidarity for either a candidate or a cause, and, the right to protest, that kind of thing. We want to preserve those things when we make rulings, and just, that sort of stuff, you can look through it. But again, I just wanted to make a couple quick videos to tag on there because I think it's all in writing really well. But for the sake of just, again, this is who I am, good person here, good faith, intervening in the case with extremely good intention, and to try to, again, speak on some of these issues that I don't think are getting effectively spoken on, and just also the concern about election interference, whether it's intended by the plaintiffs and attorneys or not. That's what's happening, especially with that judge's ruling, and how that is there's a statute in Alaska for that. It's a violation, it's a criminal violation, and you really can't alter, can't manipulate the process for district, and you can't really, you're letting these people intervene with their injunction order at the last minute, and of course the judge had no time to prepare for it, but the effects and ramifications of it, we really need to pump the brakes, in my opinion, look at the context, in my opinion, and make some better decisions. Also concerned about the precedent. And so the one other thing, and I was kind of running, I don't have much time with this thing, and I know I want to, I don't want to make an hour-long video, but talking about election interference, I think the thing that I wanted to focus on in terms of like a bullet point, when I talk about pushing the dates back, how it disenfranchises the district, I also want to talk about how the judge, I think, there's a problem with how he sort of, with his reason and logic in that September 22nd order. I talked about this in the writing too, but I want to make sure I put it in the video, sort of leans on, not just referencing the stuff in DC, which is in process and all the problems with that because it hasn't resolved yet, and it really doesn't, relate to Mr. Eastman as an individual, but I really wanted to focus on how he leans on ranked choice voting and how ranked choice voting is totally new to Alaska. A lot of people, there's different language, different, a lot of people won't even know the right. It's going to sort of prejudice the people, the voters, against ranked choice voting. It's basically not ranked choice voting. It's, again, focusing on election interference. It really, to me, is a problem because the judge is basically suggesting that people need to mark someone else on the ballot due to this process manipulation with Mr. Eastman. And how they're pushing this thing back, and it's now not up to the voters, it's up to the judge, which is a real problem. But, basically saying, well, we should mark a second choice, whoever's second is going to get in. That's not the way it's supposed to be, is what we argue in our writings. It's supposed to be, if he's ineligible before the ballot and all that stuff, then, he wouldn't be on the ballot. But if he's eligible during the election and during that process and the timeline for the civil case is afterwards, then it goes to a governor appointment if for some reason Mr. Eastman is ineligible. And we feel like that process the judge sort of outlined is not been voted on anywhere. And there's just so many different, it hasn't been scrutinized by lawmakers anywhere. You know what I mean? Nowhere in the country, but not in Alaska either. And there's just so many different problems with it in terms of, what it does. Like I said, it's going to be something where basically the judge is violating that election interference law because you're encouraging people to mark someone else, even if it's a second voter. So regardless of whether Mr. Eastman wins, or regardless of the civil case, this is basically giving those other voters a lot of good chance to get more votes, even if they're second votes, which could make them potentially win the election just based on that judge's order and based on that judge sort of telling people to vote for someone else besides Eastman, even if it's a second mark. So it's really election interference, objectively, rationally.